Accused Emanuel AME shooter Dylann Roof has been found competent to stand trial. In this edition of Quintin's Close-Ups, I speak exclusively with local attorney David Aylor. Well, David, let me talk to you about the obvious. As you know, Dylann Roof has been found competent to stand trial for the murders of the 9 people of Mother Emanuel. And actually, Judge Gergel said this, quote, "After carefully considering the record before the court, the relevant legal standards, and the arguments of counsel, the court now finds and concludes that the defendant is competent to stand trial." Gergel believes that Roof is he actually understands the nature and the consequences of the court's proceedings against him, and has the ability to consult with the counsel and assist them with preparing for defense. What does that tell you?
That just tells you at this point where he is mentally right now through the testimony that came up with the medical experts that was provided to Judge Gergel. The determination is that the case will move forward. And the key part of this is, I think a lot of people were a little bit confused, was this is not about whether or not he was competent at the time of the alleged incidents that occurred. This is about whether right now, moving forward, within a legal proceeding, he would be able to function mentally for that court hearing so that all of his rights would be preserved and protected, and he would be able to work with his counsel on making crucial decisions of what may happen, what will happen next, and understanding the potential results of his decisions within the trial.
Speaking of next, as you know, the jury selection begins tomorrow, and I know that the judge as well as the lawyers want to kind of cut down the jury selection. Talk to me more about that.
Well, you know, this is obviously a unique situation. Usually you wouldn't have pools of the size that they had to bring in for this.
Right.
And beyond that, most cases that go in front of court aren't ones that really anybody knows about. It's not something that you read about in the paper every day, and unless you were directly affected and involved, you probably wouldn't have heard of it. So you have that big building block that they have to move around, which is, of course, the notoriety of the case. And that kind of put out a lot of jurors, and that's why they had to bring in so many to start with a much larger pool. At the end of the day, though, you still want the same exact kind of jurors, the 12 plus a few extras that come in and that are non-biased, and they may more than likely would be aware of what happened, right, because of the amount of publicity involved, that they're open-minded and not made a decision upon what they think of the innocence or guilt of Mr. Roof.
And you know, I was looking at the Post and Courier article, and it says this. It's very interesting to me. It says the competency rulings looked at the defendant's mental status at the point of time. If Roof has ongoing mental health issues, his attorneys could raise questions about his competency in the future as well.
Yeah, I mean, obviously trials are very stressful things, and particularly on something like this, when you're talking about a pretty lengthy trial. So if things were to come up within the trial that put the defense attorneys, in necessary caution, that they need to bring it in front of the judge, because he has to be held competent, not just at the beginning of the trial, but for the trial all the way throughout.
David Aylor, thank you so much for your time. I really appreciate this.
Thanks for having me. Always good to see you.
Thank you.